Hello and welcome to this webinar. First of all, an apology. This was due to be hosted by Penny Bygrave, who unfortunately is poorly this morning, so you have me instead, Doug Locke. Happily, we do have fit and well our three speakers for this morning, who are Zara Ghulam Hussain, Lorna Scully and Nahida Rashid. Zara will be talking about IR35. Lorna will be talking about umbrella companies, and Nahida will be giving us an update on data protection. As Tamar said, do leave questions in the chat box, and we will try to get to those. I think probably most of them after the speakers have spoken. So the speakers will each speak for about 10 or 15 minutes, and there should be plenty of time for questions after that. And finally, if you would like any training on any of the points that are raised in the webinar today, there'll be some slides at the end of the webinar that will explain how that can be arranged. So, Zara, please go ahead on IR35.
Thank you, Doug. So as Doug mentioned, I will be providing an IR35 update and specifically focusing on the use of overseas contractors in conjunction with the off-payroll working rules. So by way of a summary, IR35 is the name given to the tax legislation in the Income, Earnings and Pensions Act 2003. It applies when a contractor provides their services through their personal services company to a client where they could be regarded as an employee of the client. Now, if considered to be an employee of the client, the fee payer would then need to make the relevant tax deductions and national insurance contributions. Now, it's a very hot topic at the moment amongst our clients. We receive inquiries from contractors, from intermediaries, and even your end user clients in relation to whether IR35 would apply in certain situations and supply chains. Now, recently, what we're noticing is that end user clients are reluctant in engaging contractors who are operating via their personal services companies due to the changes to the regulations last year, in which the responsibility to assess whether a contractor would be considered inside or outside IR35, and subsequently making the relevant income tax and national insurance contribution deductions, is passed on to the end user for medium to large businesses. Now, this required end users to conduct the relevant status determination tests and use the HMRC check employment status for tax tool, in which they would determine if a contractor is being treated as an employee or self-employed. Now, in this section of the webinar, I'll be exploring an exception of when IR35 may not apply by examining the use of overseas contractors and the conditions that need to be satisfied to rely on this exception. Now, I'll also cover the factors to consider to reduce the risk of IR35 applying. And then, as Doug mentioned, if you have any questions, please do put them forward and we can answer these towards the end of the webinar. In summary, a worker who is not a UK resident and is performing work outside of the UK is unlikely to fall within the charge to UK tax or national insurance contributions. Now, if the worker is not chargeable to UK tax or national insurance contributions, then the off-payroll working rules will not apply. So this essentially means that if an individual is not subject to UK taxes or national insurance contributions, IR35 would not need to be considered. So this would effectively apply to overseas contractors. However, it is very important to note that not only does the contractor have to be based overseas, but the services being provided have to be provided from outside of the UK. Now, in order to satisfy this exception, we need to consider the criteria in further detail. Now, for the contractor to be classed as overseas, they would have to satisfy the residency requirements. Now, UK government guidance stipulates that your residency depends on how many days you spend in the UK in the taxed year. You would be considered to be a UK resident if you do not meet any of the automatic overseas tests, or you meet one of the automatic UK tests or the sufficient ties test. Now, it's quite complicated, but I'll provide a quick summary of what these tests involve. So the overseas test states that you are automatically not considered to be a UK resident if either you have spent fewer than 16 days in the UK, or you work abroad full-time and spend fewer than 91 days in the UK, of which no more than 30 days were spent working. Now, if either of those tests are not met, then the automatic UK test could be considered. And that test states that you may be a resident if you spend 183 or more days in the UK in the tax year, or your only home was in the UK and was available to use for at least 91 days in total, and you spend time there for at least 30 days in the tax year, or you worked full-time in the UK for any period of 365 days, and at least one of those days fell in the specific tax year. So these details need to be considered, and you need to make sure that you are not considered a UK resident. And then if none of the automatic UK tests are satisfied, and the sufficient ties test should be considered. And this test, the sufficient ties test, states that for those individuals who want to spend more than 16 days in the UK and do not want to work full-time abroad, it may still be possible to become a non-resident. However, the time spent in the UK needs to be reduced, along with the number of ties they have with the UK, such as family accommodation, work tie, the 90-day tie, and the country tie. So the residency, as you can understand, the residency tests are quite technical, and so it's important to consider your current and future arrangements and whether the residency rules would apply in your situation, in order to ascertain whether the contractor concerned would be considered a resident of the UK and subsequently subject to UK tax. However, if the contractor is not considered to be a UK resident, they could be considered to be outside the remit of IR35. As expected, tax advice should be obtained in relation to the residency tests as well. Now, along with the residency requirements of the contractor, in order for them to be based overseas and satisfy the overseas exception, it's important to also consider where the services are being provided as well. So the general approach is, if the services are being provided in the UK, this would attract IR35, and you would have to carry out the relevant status determination tests to check if the individual is being treated as an employee and whether they need to have the relevant taxes and national insurance contributions deducted. Now, there is an exception for the services that are considered to be merely incidental to the duties performed overseas. So essentially, even if the services are being provided in the UK, if they are merely incidental to the duties performed overseas, that could still satisfy the exception. Now, in accordance with Section 39 of the Income Tax, Earnings and Pensions Act, to determine whether duties performed in the UK are merely incidental to duties performed overseas, it is necessary to consider both the nature of the duties performed in the UK and their relationship to the duties performed abroad. Now, HMRC have actually provided quite helpfully guidance in which they provide also examples of duties that could be considered merely incidental, although obviously each case will depend on its particular facts and the types of activities that are being carried out. Now, merely incidental duties could include arranging meetings and business travel, feedback on employee performance and business results, but this shouldn't involve the individual concerned in preparation or analysis whilst in the UK. And then also input to team restructuring and staff matters, and reading generic business emails that don't relate directly to their role could be considered merely incidental duties. Examples of duties that could be considered not to be merely incidental could include instructions or guidance to colleagues and team members, work carried out on issues or projects that do not come to fruition, and reporting on performance or business results where these are part of the individual's core duties. if the individual has to analyze reports or recommendations, or they have to prepare work that lead to discussions or meetings or presentations with clients, or meetings with board members or colleagues, or follow-up discussions, any sort of discussion or meeting, really, it could be considered merely not to be merely incidental. And so this may then lead to the overseas exception not being satisfied. So essentially, it is important to consider the contract and the duties of each engagement and the role involved in order to be able to claim whether these activities are merely incidental or not. Even though you may be considered to be overseas in light of what I've covered, it would still be useful to ensure that the contract in place reflects that the contractor is not an employee or treated as an employee. And so there are certain factors to consider which should be reflected in the contractor's contract to reduce the risk of IR35 applying. Now, I'll just run through those factors. Now, one being the right of substitution. Now, you should consider whether the contract includes a right of substitution, as this could be an indicator of a non-employment relationship. So the right of substitution should ideally not be limited to the company being able to choose a substitute, and the contractor should have the freedom to allocate such a substitute. However, even if such a right is incorporated into the contract, it's important to confirm with the company whether this right actually exists in practice. In HMRC's guidance, they've actually said that many contracts contain these clauses, these substitution clauses, that appear to give a right of substitution, but it seems likely that many of these clauses have only been inserted to try and break the requirement for personal service and change the contract from one of service to one of services. So normally a client requires the services of a particular worker, and a substitute would not be acceptable. So therefore, there are doubts when these clauses are inserted just for the sake of them being inserted. This demonstrates that in order to negate the requirement of a personal service being provided, although a right of substitution in a contract will be useful, it needs to be a genuine right that can be exercised in practice, and preferably unfettered and not limited. Another factor to consider when considering reducing the risk of IR35 applying is control. So you need to ensure that in practice that the contractor concerned is not under the control of the company. The more the contractor can show that they are genuinely in business in their own account, the more likely they could be viewed as an independent contractor. Another important factor to consider is that the contractor is not an employee of the company, is to ensure that they're not integrated within the company. The contractor should not be subject to a rota that they're required to work. They shouldn't appear to be part and parcel of either company more than is necessary. So, for instance, if they're linked to the company website or affiliated with the company, like having a company email address or subject to the company's appraisal process, that would show that they're integrated, which would not support the argument that you don't want IR35 to apply. And also using their own tools or equipment could negate the existence of an employee relationship. Now, another factor is mutuality of obligation. The contractor should not be under an obligation to accept and complete the work, and the company should not be under an obligation to provide the work, contractor with paid work. There is recent case law, and we did mention this in our last webinar, in the case of Nursery and Midwifery Council in Somerville, which suggests that the mutuality of obligation may not be a key factor in the worker status test. In that case, the Court of Appeal concluded that mutuality of obligation is not a requirement of worker status, and rather control and personal service are more indicative of employment status. There's also case law, on the other hand, which has shown that mutuality of obligation is still a factor to be considered when demonstrating worker status. However, it would still be useful to just ensure that contracts do not demonstrate that a contractor needs to accept the work and that a company needs to offer the work, just to cover your bases. Also, the contract should, if possible, be structured by reference to completion of a project rather than the time worked. Now, if payment could be structured by reference to completion of a project, this would be more appropriate and would then indicate that the contractor is acting as a self-employed contractor rather than an employee. And some element of financial risk and reward should be incorporated into the contract. So for instance, if there are penalties or bonuses for early or late completion of work, that would be helpful. And the contractor should also be responsible for their own financial risk, such as arranging their own insurance whilst being engaged by the company. Intellectual property is another factor to consider. Now, in the employment context, the ownership of intellectual property created by an employee in the course of his or her employment generally vests in the employer, but this approach doesn't apply to a relationship between a contractor and a company. So the individual will generally be the owner of any intellectual property that they create during their assignment, and so essentially making sure that's reflected in the contract would be useful. And lastly, it would be helpful for the agreement to provide a statement, making it clear that the relationship of the consultant to the client is that of a self-employed independent contractor, and nothing in the agreement shall render them to be an employee or a worker of the client. But again, even though it would be helpful to include such a clause to ensure there's no confusion at the outset, it's unlikely that employers or contractors will just be able to rely on such a clause if there is a dispute with HMRC, because they will look behind any contract and they will assess the reality of the arrangement, and not only what the contract says. So that's it in a nutshell. There's a lot to consider for this overseas exception to apply, and then also generally how to reduce the risk of IR35 applying. But if anyone has any questions in relation to this overseas exception, and whether it could be satisfied, or whether the current arrangement you have in place could satisfy the overseas exception test, if you need assistance in relation to IR35 or any complex supply chains, please do get in touch. But that's it from me, and I believe Lorna will be following with that topic. Thank you.
Hi, thanks, Zara. My name's Lorna Skelly. I'm a senior associate in the employment team at BWV, and for the next 10 minutes or so, I'm going to talk to you a little bit about umbrella companies. So there's been a significant rise in the use of umbrella companies in recent times, so it's a good opportunity just to take a closer look at them. So if we skip to the next slide, and we'll take a look at what is an umbrella company. Well, it's important to note there is no agreed legal definition of an umbrella company, so the term can mean different things to different people. But in general, the term is applied to a company that directly employs a worker who provides their service under temporary contracts elsewhere, and who uses an employment agency to find them those contracts. And this is the model that the government refer to in their guidance, which I've put up on that slide. And as you can see from the end of the definition, what that means is that the umbrella company has to comply with employment law. So how does that work in practice? Well, it means that the umbrella company is responsible for paying the employee subject to usual deductions of tax and NI, which it must account for to HMRC. But it must also pay the employee other sums which are due to employees, such as things like statutory sick pay if they're off sick, holiday pay, statutory entitlements such as statutory maternity pay, statutory paternity pay, etc., if applicable, employer pension contributions. And in order to do this, the umbrella company will generally receive the money that the end user client is paying for the services of the worker, and it'll come via the agency. The employment agency will deduct their fee for the work finding services, pay it onto the umbrella company, And that's generally known as the sort of assignment rate or contract rate. And then the umbrella company will deduct from that certain sums to cover the things that it has to pay, things like holiday pay, employer pension contributions, potential SSP or other statutory payment liabilities, employer national insurance contributions, and the apprenticeship levy, if applicable. And also it will deduct an administration fee to pay itself for the services that it's providing. And then it will take the leftover sum, which it'll attribute to the employee as their wages or gross pay. And then it will deduct from that gross pay income tax, employee national insurance and employee pension contributions. It'll account appropriately to HMRC and then pay the remainder to the employee as their net pay. So why are people using this model, which does on the face of it sound quite complex? So let's have a look at the benefits of this model. If we could move to the next slide, please. So as Zara's already touched on, the extension of the off-payroll working rules into IR35 has meant that what was a previously used very common model of engaging clients, engaging contractors, either via an agency or directly, but through their own personal service company, which the contractor would use to pay themselves via, has become less attractive, particularly to end user clients. And they're often reluctant nowadays to engage in that model. And that's because, I think as Sarah has touched on, where IR35 applies, so where a contractor is working through a personal service company, the end user is obliged to conduct a status determination to assess whether the relationship between them, the end user, and the worker would, but for the presence of the intermediary, the personal service company, be one of deemed employment. And Zara's talked about the various tests that apply. If it is a relationship of deemed employment, then the fee payer, so in a tripartite arrangement, that would be the agency, is obliged to deduct tax and national insurance from the fee paid to the personal service company. But where we use an umbrella company model, IR35, which is set out in section 10 of ITEPA, doesn't apply. And instead, for tax purposes, it's covered by section 7 of ITEPA, which are the agency rules. And so from the client's perspective, it's freed of the burden of having to worry about doing a status determination and wondering whether or not IR35 applies. For an agency, it's also quite an attractive model because it's taking away the risk of IR35 applying, which generally speaking, it would be the fee payer who would be obliged to deduct tax under. And also, if the worker is employed by an umbrella company, not directly by them, then it's the agency doesn't have to worry about complying with payroll rules or providing other employee benefits. And it should also give it an enhanced ability to attract clients because, as I've just said, clients are often now reluctant to use the old traditional sort of personal service company model. And in some cases, the agencies can also get the benefit of a referral fee from an umbrella company if they recommend an employee out to use a particular umbrella company. And for the employee, they no longer have the burden of having to run their own personal service company because the umbrella company is doing all that for them. And significantly, they also get employment rights and protections such as talked about the right to holiday pay, statutory sick pay. And also after 2 years, they'd get things like the right to claim unfair dismissal and entitlement to a redundancy pay. And for the umbrella company, obviously the main benefit is that it provides it with the opportunity to generate income from the fees it charges for providing its services. If we can move on to the next slide, please. But as well as obviously the benefits of the model we've just talked about, there are also some drawbacks. Unlike employment agencies, umbrella companies are not regulated by the Employment Agency Standard Inspectorate and in fact are largely unregulated. And this has led to some concerns that some umbrella companies are exploiting workers, perhaps not paying all the sums that are properly due to them over to them. And there are also some unscrupulous umbrella companies out of there, which the government has warned are engaging in various forms of tax avoidance. So it's very important both that an agency and a worker carries out thorough due diligence on any umbrella company that it is going to engage with. Otherwise, it could find that it's on the hook for tax liabilities, particularly where we've got unregulated small umbrella companies who effectively will just become insolvent if there's any liabilities put against them. In terms of tax efficiency, obviously, employees who used to engage through that personal service company model where they could pay themselves through dividends, which is more tax effective than paying themselves income subject to income tax, they've lost that tax efficiency. But in reality, if the relationship is one that would have, if it had been assessed under IR35, have been deemed employment in any event, there's actually no tax benefit to them. But I suppose one of the significant drawbacks is that it does require some really complex contractual arrangements. The agency is going to need to put in place the key information document with the worker, and it's also going to need terms of engagements both with the client and with the umbrella company. And the umbrella company is going to need to put in place an employment contract with the worker. Also, the umbrella company itself, as the employer, risks employment tribunal claims being brought against it by the worker if they feel that they have been exploited or that the umbrella company has somehow failed to comply with their employment obligations. So it is important to balance the pros and cons of the arrangement. And it's also worth pointing out that the government has promised to introduce some reform in this area. It certainly recognises that it is largely unregulated, and it has stated an intention to ensure appropriate regulation. That might be by extending the role of the Employment Agency's Standard Inspectorate to regulate umbrella companies, or it might mean putting umbrella companies under regulation of the single employment enforcement body, which is already regulating, took over from things like the gangmaster's license and enforces things like national minimum wage as well. But although we've had a call for evidence, and that call for evidence closed in February, we've not yet got firm plans. I know the government has been criticised for not acting quick enough, but I think probably at the moment, the government's got bigger things to be worrying about. So if we could move on to the last slide. And this is a question that does seem to keep arising when we're looking at umbrella companies. And it's about what ability agencies have to require employees to work or to use umbrella companies or specific umbrella companies that they would like them to use. So an employee working through an umbrella company is still an agency worker for the purposes of the agency worker regulations. If they're using an agency to find them work, the agency worker regs specifically say that putting in place an intermediary like an umbrella company will not prevent the agency worker regs from applying. So, as most of you will know, an agency is prevented from charging workers a fee for offering its work finding services, but it's not prohibited from charging a fee for other ancillary services. But where it is making a charge for providing those other ancillary services, what it can't do is make the provision of its work finding services conditional on the work seeker using any of those other services, whether provided by the agency or a connected business. That's the wording in the regulations. So therefore, if the employment agency is connected in some way with the umbrella company, which, as we know, is going to charge a fee for providing those services, then it would be breaching the conduct regulations if it were making its services conditional on the agent and on the worker using that specific umbrella company. But if there's no connection, then in principle, there's nothing to prevent the employment agency requiring the agency worker to use an umbrella company, even a specific umbrella company. But good practice would say that the best thing to do is for the employment agency to have what they call a preferred supplier list, which they will have conducted thorough due diligence on, which they're then able to recommend to the worker on the basis that they've conducted the thorough due diligence and they're satisfied that the umbrella company is one which is acting in compliance with all relevant legislation. So that was all I wanted to say on umbrella companies. And now I'm going to hand over for the next speaker. Thanks.
Thank you very much, Lorna. Hello, everyone. My name is Nahida and I'm a solicitor in the Commercial and Charities team at BWV. I'm going to give a brief overview on what you need to do to be compliant when carrying out direct marketing and using cookies on your website. So direct marketing is defined in the Data Protection Act as communication by whatever means of advertising or marketing material which is directed to particular individuals. So this could be contacting someone by email, post, through social media, or calling someone directly to ask if they're interested in a particular role or if a business is open to new candidates. In order to carry out direct marketing, the rules that you need to comply with is the UK GDPR and the rules on electronic marketing in the Privacy and Electronic Communications Regulations. I'll refer to this as the PECR going forward. So the PECR mainly applies to unsolicited marketing. That is any message that has not been specifically requested by an individual. So even if a client has opted in to receive marketing from you, although it counts as unsolicited marketing, an opt-in means that the customer agrees to future messages and is compliant, and that complies with the PECR. So legal requirements. When your recruitment business is planning their marketing activities, the legal requirements under the PECR and the UK GDPR should be considered from the outset. There's 3 marketing essentials that you should consider. Firstly, checking that your processes are user-friendly. So when you reach out to existing and prospective clients, provided that you have their consent to do so, which I'll shortly come on to, always check that the activity allows for the privacy information to be accessed and viewed easily. So whether that's through giving the information by email or having it easily visible on an agency's website. Secondly, it's really important to make sure that your privacy notice is up to date and contains all the information that an individual is entitled to know about in relation to your use of their personal data. A privacy notice should include the types of personal data being processed, the purpose for using their personal data, and the appropriate lawful basis for processing. Particularly if you are using consent under the PECR, then it makes sense to have consent as your lawful basis rather than having legitimate interests. Finally, again, so if you are allowing consent, you must make sure that you meet all the conditions of consent. And for consent to be valid under the GDPR, it must be freely given, specific, informed, and unambiguous. Essentially, you need to tell the person exactly what you're using their personal data for and allow them to make the decision. Consent can also not be bundled for one activity and then used in respect of another activity. And it also must not be conditional, and individuals must be able to withdraw their consent easily at any time. So these are the 3 marketing essentials that you should consider, and the ICO has taken non-compliance with direct marketing very seriously, with recent fines being up to 85,000 and 200,000, but it can also go up to as high as 500,000. Next slide, please. I'll now just give a short overview on cookie compliance. So cookies, as you know, are used to track our online activity. You will see that every time you go on a website, there's always a little pop-up banner which asks you to accept or reject cookies. And under the PECR, again, you must obtain prior consent before placing cookies on a user's device unless a website is unable to operate without them. And that's usually when a website needs essential cookies, and they're usually for browsing on a website that
Nita, I'm so sorry about this, to interrupt you again, but I'm still having a bit of trouble hearing you clearly. I think it's the room thing. So someone is about to hand you some headphones, which will make that, which will hopefully improve the situation. But in the meantime, should we just sort of pause there and take a couple of questions while those headphones are being sorted out? We've had two. One is for Lorna, I think. So Lorna, if you're there, the question is paying via an umbrella company using personal CIS, presumably construction industry scheme, into the worker's personal bank account still compliant?
So essentially, the construction industry scheme is designed to cover self-employed individuals. But the IR35 rules take precedence over the construction industry scheme rules. So if you've got an individual working ostensibly in construction, but working through a personal service company, so that means that IR35 would apply, then the end user will still need to undertake a status determination to assess whether or not the relationship would be, but for the presence of the personal service company, be one of deemed employment. And if so, then tax and national insurance will need to be deducted. If the individual is not working for a personal service company, then but self-employed, then obviously then the simple construction industry scheme rules will apply because IR35 won't apply, so that would be fine. But in terms of where it's as if we're paying via an umbrella company, so the model of umbrella company that I was talking about was one where the umbrella company is directly employing the individual, and obviously the whole point of the umbrella company directly employing the individual is that the umbrella company will be deducting appropriate tax and national insurance for, through PAYE. That's the whole point. So I think possibly this question is, and as I said at the start, there are different models that umbrella companies can mean different things to different people. I suspect this is a different model of umbrella company, not one where the individual is deemed an employee, but possibly one where they're deemed self-employed and obviously not working through a PSE because they're being paid by the umbrella and simply having the CIS deducted. I think in principle that would be fine if they're genuinely self-employed, but obviously it falls to a status determination. I couldn't say without assessing whether or not they are genuinely self-employed. It goes back to that tests that Sarah was explaining about control and substitution and all those kind of things.
Super. Laura, thank you very much.
Thanks.
Zara, one for you. When considering whether IR35 applies, does the residency of the intermediary need to be considered?
Okay, yeah, we actually had a client with a similar sort of question. So in the HMRC guidance, it does state that the residency of a worker's intermediary does not need to be considered when deciding whether IR35 applies. So if a worker's registered their intermediary overseas, that will have no bearing on whether the off-payroll working rules apply or not. But essentially, this would then imply that it's only the contractor's residency and the end client's residency which need to be considered. But I would also look into that in further detail, because if a worker set up their limited company, overseas contractor, if they've set their limited company in the UK, if it's registered in the UK, they would have potentially a registered office in the UK. And this may affect the contractor's residency status. So we'd need to look into that in further detail, just to check really if we're complying with the criteria of residency. But apart from what HMRC has said in that guidance, there's nothing else that they've actually provided in further detail in relation to this. So we just need to tread carefully in those circumstances. But for now, it's simply saying that the residency of the workers intermediary doesn't need to be considered.
Lovely. Zara, thank you very much. Nahida, how is it going? Do you have those headphones? You do. Brilliant. Brilliant.
Hello. Is this better?
That's much better. Yeah. Apologies, Nahida, and to everybody listening. Nahida, would you perhaps like to sort of rewind to the beginning of that slide and take it from there?
Yeah. If you go back to the last, that one. Thank you. Okay. So I'll start again from cookie compliance. As I was saying, cookies are used to track our online activity, and you'll notice that every time you go on a website, there's always a little pop-up banner which asks you to accept or reject cookies. And under the PECR, you must obtain prior consent before placing cookies on a user's device, unless the website cannot operate without them. So these are usually essential cookies when you need to browse a website and it has features where you need to access secure areas of a website. To ensure you are compliant with the law, you can obtain consent in the following 3 ways. And the most common is obviously using the pop-up cookie banners, and you basically ask users to accept or reject cookies, and that allows them to have an active choice rather than relying on deemed consent. Secondly, you can also allow users to have preference on which cookies they want to accept and personalize their interaction on different features of a website, such as videos. And lastly, you can also display reminders at the top or bottom of your web page asking for consent with a link to your agency's cookie policy. Next slide, please. So the French regulator has taken this approach very seriously, and they recently fined Google and YouTube a fine of 150 million euros. And they found in their investigation that what Google and YouTube were doing was allowing a single click for the immediate acceptance of cookies, but then with the option to refuse cookies, it required several clicks. And this is an important reminder for recruitment agencies placing workers from the UK into the EU. So it's also important that you comply with both the EU's requirements on consent as well as the UK's requirements. Going forward, we are likely to see some changes in the use of cookies. You may have heard that the UK government has formally announced its plans to introduce a data reform bill. And one of the reforms will be a new opt-out model for cookies. And the aim is to reduce the need for users to click through consent banners on every website they visit, meaning that people will now start seeing fewer pop-up banners appearing online. We'll be learning more about the data reform bill as the government continues to introduce the plans, and we'll share any new information in our blogs and upcoming webinars. Thank you very much for listening. I'll now hand back over to Doug.
Nahida, thank you very much, and apologies again for the problems with the audio. That was a whole lot better when the headphones are on there. So thank you very much.
Thank you.
Apologies to people listening. If you missed any of that from Nahida, do please get in touch with Nahida, who I'm sure will be happy to fill you in on any bits that you might have missed. We have, at the moment, we have no more questions. So if anyone would like to ask a question, then please do so now, or alternatively, please do get in touch with any of the speakers direct, and their details are on the flyer for this session. Finally, then, if there are no more questions, here are the details of the training that is available on the subjects that have been covered today, e-learning training. So again, if you'd like to have any of that training, then do please get in touch with us. Any of the speakers will be happy to help you sort out that training.